Hello, everyone, and welcome to LiveLaw Academy. Today, I am here to discuss a very important topic from the law of evidence, and that is the theory of relevancy. Imagine with me, we are sitting inside a courtroom and the trial is going on. The case is before the court of law, and all the facts related to the case are flying around the courtroom. Every single fact. Who said what? Who saw what, who felt what, and all the other things. Now, whether the court should consider all these facts to decide the case, whether the court should consider everything, every single fact that is related to the case, the answer is no. And that's where the theory or the concept of relevancy, it steps in. In this session, we'll start with the basic. First, we will first understand what is the meaning of the word fact. What is fact in issue? When we will say that a fact is a fact in issue, and when does a fact become a relevant fact? The two main doctrines or approaches related to relevancy and the relationship between relevancy and admissibility with the help of an example. Let's start with the basic question. First, what is a fact? For this, we can refer to the Bare Act. Let me just open it. It will be easy and more clear when we see the text on the screen. So it is from Bharatiya Sakshi Adhiniyam, section 2F. Earlier, this used to be section number 3 of Indian Evidence Act. The exact same definition. It says that fact means and includes anything, state of things, or relation of things capable of being perceived by the senses. Then it has a second clause which says any mental condition of which any person is conscious. We'll come to the illustration. First, let's understand what is clause 1 and what is clause 2. So, clause 1 is basically dealing with the external facts, the physical facts, those facts which can be perceived by the five senses. See, anything observable, any state of things, relation of these things, these are capable of being perceived by our senses. These are external facts. Then clause 2 deals with the internal facts. It deals with psychological conditions, the mental conditions which become observable when something is either said or when they are acted upon, right? So fact, they can be both physical as well as mental. They can be internal as well as external. Now, to make things further clear, let's see what is provided in the illustration. Illustration. First, that there are certain objects arranged in certain order in a certain place is a fact. Now, why this is a fact? First part, that certain objects are arranged. This shows us the state of some things, and state of things is a fact. Then, in a certain order, in a certain order, in a certain place. This shows us what is the relationship between those objects. And relation of things is a fact. Second illustration, that a person heard or saw something is a fact. Why it is a fact? Again, external facts. These are external facts. Because anything which is heard, anything which is said, and anything which is seen, these are observable by our five senses. These are physical facts. These are external facts covered by clause 1 of 2F. Then, again, this is an example of the same clause 1, that the person said certain words, because when you say something, you can perceive the words, you can hear them. Again, last illustration deals with the clause 2, certain internal facts. that a person holds a certain opinion, has a certain intention, acts in good faith, or fraudulently. All these things are what? These things are psychological conditions. These things are mental conditions, right? So illustration 4 has a relationship with the second clause of 2F of Bharatiya Sakshya Adhiniyam. Earlier, this was section 3. I have told you, right? Now, the facts can also be positive facts and negative facts. Positive facts mean that something exists or something has happened. For example, A was present on the crime scene. This is a positive fact. Then negative fact means that something has not happened or something did not exist. For example, A never entered that building where the crime was committed. This is a negative fact, right? Now, let's focus on a particular category of fact, which is fact in issue. The definition of fact in issue is also provided in the Ware Act. Let's see that, and then I will simplify that definition for you. Let me again share my screen. See, this is section 2G of Bharatiya Sakshya Adhiniyam. It was earlier under section 3. Fact in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non existence, nature, or extent of any right, liability, or disability asserted or denied in a suit or proceeding necessarily follows. Right? Now, what does this mean? This simply means that the central fact, the main fact, the core fact on which the decision of the case is dependent, that fact is a fact in issue, whether it's a physical fact or a mental fact or a psychological fact, whatever. If that fact forms the crux of the matter, forms the core of the matter, right? And if that fact is decided, then a legal consequence will follow. And what is that legal consequence? That either the right or liability or disability exists or does not exist. On such things, these legal consequences, what is dependent? The final decision of the case. So facts in issue are those physical or psychological facts, are those positive or negative facts on which the decision of the case is dependent upon. They are the central facts, they are the main facts, they are the core facts, right? Such facts will be called facts in issue. Illustration is provided in the Ware Act. Let's understand the definition in light of this illustration. It says A is accused of the murder of B, and at his trial, the following facts may be in issue. What are these facts? 4 facts are provided. That A caused B's death. Now, why this will be a fact in issue? Because the moment you establish that A has caused B's death, what will be the legal consequence? The legal consequence will be that the liability will be established. And when liability is established, you are deciding the case and becomes a fact in issue, right? Second, that A intended to cause B's death, because cause and intention, the act and intention, they together will form the ingredients of the offense of murder, right? Hence, this will also contribute in establishing the liability. That's why it is also a fact in issue. Then third, that A had received grave and sudden provocation from B. Now, why this is a fact in issue? Because in case of murder, there are certain special exceptions, and grave and sudden provocation is one of those special exceptions. And the effect of existence of a special exception is what? The offense will be reduced from murder to culpable homicide. That is the effect. So this particular fact that A had received grave and sudden provocation from B will impact what? Will impact what? It will impact the nature and extent of the liability, because then liability is reduced from murder to culpable homicide. Next fact, that A at the time of doing the act which caused B's death was by reason of unsoundness of mind incapable of knowing its nature. We all know that unsoundness of mind is a general exception, and general exception results in complete exoneration. The person will not be liable at all if the act falls in any of the general exceptions. So this actually refers to the defense of insanity, the defense of legal insanity, unsoundness of mind, right? So this fact will be a fact in issue, because if this fact is established, then the liability no longer exists. And we have seen in the definition, non-existence of any right, liability, or disability will be a fact in issue. If any fact which goes on to prove such non-existence will be a fact in issue. That is why all these four facts are set to be here, that they can be facts in issue in a murder case. Right? Now we are moving on to the main issue for today, the relevancy. When we will say that certain facts are relevant, and what is the importance of that? The importance lies in the fact that I will show you the provision in a while, in the fact that Evidence Act clearly states that evidence can be given only of a fact in issue or a relevant fact and of no other. So only a relevant fact is admissible or a fact in issue is admissible. You can give any piece of evidence relating to these two categories of facts. Right? Now for relevancy, there are two major approaches. One is the Thayer doctrine, and the other is the approach of James Stephen, who was the person responsible for drafting Indian Evidence Act. So, as per Thayer doctrine, it says that any fact which has a logical connection with the fact in issue, with the main fact, with the main transaction, any kind of link, any kind of logical link between a fact and the main fact makes the other fact a relevant fact. So it is a theory on logical relevancy. It will not be dependent upon the probative value of that fact. In any way it has a logical connection, it should be made admissible. Apart from those cases in which the admissibility is barred on some ground of public policy, for example, privilege or public interest, only on those cases, in those situations, evidence will not be taken. But evidence of every such logically connected fact should be taken into consideration. This is the Thayer doctrine. It has a wider approach. Now, as compared to this, James Stephen's approach is a tight approach, is a narrower approach. According to this approach, only those facts which are expressly made relevant in the statute will be relevant facts for the purposes of evidence. Any other fact, even though it is connected logically to the main transaction, even it is connected to the main issue, main fact in issue, if it does not find any place in the provisions relating to relevancy, which is chapter 2 of both Indian Evidence Act and Bharatiya Sakshi Adhiniyam, if any such fact is not mentioned in chapter 2, then you cannot give evidence, barring few exceptions, though, but they are not as important for the purpose of this discussion on relevancy. Right? Manifestation of this approach you will see when you will read section number 3 of Bharatiya Sakshi Adhiniyam, which was earlier section 5 of Indian Evidence Act. along with section 2, the definition of relevant fact in Bharatiya Sakshi Adhiniyam, exactly same definition which was there in section 3 of Indian Evidence Act. Let's see. Let's see. Let me just show you. See, this is section number 3, Bharatiya Sakshi Adhiniyam. Earlier, section number 5, Indian Evidence Act. What does it say? Title is Evidence may be given of facts in issue and relevant facts. I have already told you this. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue, that is the main fact, and of such other facts as are hereinafter declared to be relevant, and of no others. These words are important. And of such other facts as are hereinafter declared to be relevant, which means expressly mentioned in the provisions hereinafter contained. 4 to 50 of Bharatiya Sakshi Adhiniyam and 6 to 55 of Indian Evidence Act, and of no others. So only fact in issue and relevant facts are admissible, and only those relevant facts which are expressly declared to be relevant in the provisions of the Act. Right? The definition of relevant is given in 2K of Bharatiya Sakshi Adhiniyam. A fact is said to be relevant to another when it is connected with the other in any of the ways referred to in the provisions of this adhiniyam relating to the relevancy of facts. It's simply again directing you to the same provisions, right? So it talks about legal relevancy, not only logical relevancy. That logically connected fact must find a place in chapter 2 to become a legally relevant fact. And that is why you will find in many questions in the examinations asking you to explain the statement that all logically relevant facts are not legally relevant. This is the reason behind it. Thayer doctrine is related to logical relevancy, whereas James Stephens' approach is related to legal relevancy. Right? I hope you have understood this much. Then what happens when a particular fact is declared to be relevant, is found to be relevant under Indian Evidence Act of Bharatiya Sakshi Adhiniyam? Does it automatically become admissible? The answer is not always, because there are certain exclusions. Let me explain this to you in a very simple, by way of a very simple example. Again, imagine with me. There is a courtroom having multiple doors, and each door represents a provision relating to relevancy, legal relevance. Outside the courtroom, there are many facts that are waiting to be admitted in the case, in a particular case. The prosecution seeks to bring a particular fact through one of the doors. And then the judge asks, in what manner this particular fact is relevant? If it is not relevant, it will not be admissible. Right at the outset, it need not be considered. Section 3 of Bharatiya Sakshi Adhiniyam and Section 5 of Indian Evidence Act. So the prosecution says that, sir, honorable judge, it is a confession which is declared to be relevant under 21 of Indian Evidence Act. Then the judge says, okay, open the door. Then the door is opened. The fact is there. The confession. At that moment, defense says, it objects that, judge, it is a confession which was given to the police officer. Hence, barred under Section 25 of Indian Evidence Act. There is an exclusion. Then the judge says, okay, stop. The fact is stopped at the door. Then the judge directs that the bar on the door should be brought down. He orders the bar to be brought down. Now now the doors are open. The fact is there, but now there is a bar across that door. Here at this stage, prosecution says that though it was given to police officer, it led to a discovery of fact for which an exception is contained in section 27 of Indian Evidence Act, and hence it becomes admissible. It is an exception. Then the judge again directs that the bar should be brought up again and the facts should be made admissible. That's how it becomes admissible. And that's how relevancy and admissibility, they interact with each other. Right? See, this theory of relevancy, I have tried to make it as simple as possible for you. And this theory of relevancy is very important for everybody who is from law background, for law students, for practitioners, for future practitioners, for anybody who is preparing for judicial services. Because ultimately, if you are not familiar with these concepts, you will not be able to use them as dictionary and translate your case or arrive at a decision. Say dictionary is helpful when you have to find out the meaning. Same is with the cases. To arrive at a decision or to make the judge understand your side of the story, you need to translate the case. And these relevant facts, they help you in translation. That is the importance of understanding this theory of relevancy and the provisions of Indian Evidence Act. You must be, every successful lawyer is the one who is able to use these provisions like a dictionary and translate the case in the simplest way possible. With this, we come to an end of this session. If you have liked this video, if you have liked this session, if it is of some usefulness to you, then I request you to please like and share. And you can also comment and mention in the comment section any particular topic or area of law that you would like me to discuss. And I'll do that in future sessions, right? So don't feel any kind of hesitation. Thank you for joining me today. Take care and I'll see you in the next one. Thank you so much.